JoJo's chair right here. He was in here helping me with something that we're doing that we're extremely excited about. And if you're not already following the van.hall channel, please make sure you do. van.hall. The link will be below in the descriptions. Okay. All right. Because what I'm doing over that channel, I'm extremely excited about it. But only follow that channel if you want to learn the behind the scenes type of things that we're doing, because I'm trying to help people start their own internet careers based off the knowledge that I have come across throughout the course of my journey of obviously. All right, so we about to check out a conversation, not necessarily a conversation, a questioning between Ted Cruz and Supreme Court Justice Ketanji Brown Jackson. The only reason why is because I checked out a conversation between she and Tom Cotton. And I don't know why, but for some strange reason, she refuses to answer questions. And if you are a Supreme Court Justice, okay, I would say me. If I'm the Supreme Court Justice, I'm answering everything. And I'm like, I'll probably be filing my nails while I'm doing it. Every single thing you ask me, I will give you brutal honesty. But when you talk to people and they're not trying to answer your questions, you wonder, do they have something to hide? That's what I wonder when I hear her speak. So here we go. Hey, what's up, guys? Welcome back. All right, so we about to check this out. Y'all let me know whatever y'all want me to know in the comments. I just want to see if she's going to answer any questions that Ted Cruz brings her way.
Judge, good afternoon.
Good afternoon, Senator.
Under Article 3 of the Constitution, federal courts have jurisdiction over only cases and controversies, which means under the Constitution it has to be an actual dispute, that federal courts cannot simply issue advisory opinions on a question they may have a view on. And one component of Article 3 jurisdiction is the requirement of standing, that in order for a plaintiff to have standing to bring a case.
Thank you, Rancho Sauce.
That plaintiff, at least generally speaking, must have a real and concrete injury. Is that right?
That is correct.
So, for example, that means that even if I might have a disagreement with some particular policy or some particular law, that I can't bring a case unless I am personally aggrieved by that policy or that law. So, for example, you're in my alma mater, Harvard, is currently being sued for its explicit and, in my view, egregious policy of discriminating against Asian Americans. Even though I think that policy is egregious, I, as an individual plaintiff, could not bring a lawsuit challenging it because I am not Asian American. Is that right?
If you brought a lawsuit, the court would have to evaluate whether you had an actual injury in order to be able to determine whether it had subject matter jurisdiction to hear the suit.
But if I'm not in the class being discriminated against, then I don't have the ability to bring the lawsuit. Is that right?
I think you'd have to have an actual injury. Certainly people, I think, who are in the class could claim that they had an injury for that purpose.
So now you're on the Board of Overseers of Harvard. If you're confirmed, do you intend to recuse from this lawsuit?
That is my plan, Senator.
Okay. We discussed yesterday how the standard for race discrimination was strict scrutiny. The court has laid out a different standard for gender discrimination. What is the constitutional standard that applies to gender discrimination?
Gender discrimination, the court has held intermediate scrutiny applies, which is that the government has to have an important interest.
Now, someone said, Travis D. Creeker says, Ted Cruz left Texas to freeze while he and his family dipped the state. Never forget. Okay, I can't forget something I don't already know. Please give me more information about that. I didn't know anything about that. He left Texas to freeze? Yeah, I would like to hear more about that.
And the tailoring doesn't have to be as narrow.
Right. So yesterday, under questioning from Senator Blackburn, you told her that you couldn't define what a woman is, that you were not a biologist, which I think you're the only Supreme Court nominee in history who's been unable to answer the question, what is a woman? Let me ask you, as a judge, how would you determine if a plaintiff had Article III standing to challenge a gender-based rule, regulation, policy without being able to determine what a woman was?
Now, that's the thing, too, that gave me a little bit of pause when it came to her because, and obviously I have not seen this yet, but I'm glad that Ted Cruz is bringing this conversation back to the forefront, because if you are yourself a woman and you can't say what a woman is, then that tells me that you're protecting something. You're either protecting your future interest, like I don't know if you're considering running for, a higher office later on in life, or maybe you're protecting people or certain policies that are supported by certain people who are the reason you're in your position right now, and you don't want to bite the hand of the people who are taking care of you. But it still comes off as disingenuous if you're asked a question that should be so easy for you to answer, but yet you decide to skate around it just to protect your own hide. That right there gives me pause when it comes to supporting you. So it makes me question your character and the integrity that you bring to the job.
So, Senator, I know that I'm a woman. I know that Senator Blackburn is a woman, and the woman who I admire most in the world is in the room today, my mother. It sounded as though the question was...
But let me ask, under the modern leftist sensibilities, if I decide right now that I'm a woman, then apparently I'm a woman. Does that mean that I would have Article III standing to challenge a gender-based restriction?
Senator, to the extent that you are asking me about who has the ability to bring lawsuits based on gender, those kinds of issues are working their way through the courts, and I'm not able to comment on them.
Okay, if I can change my gender, if I can be a woman, and then an hour later, if I decide I'm not a woman anymore, I guess I would lose Article III standing. Tell me, does that same principle apply to other protected characteristics? For example, I'm an Hispanic man. Could I decide I was an Asian man? Would I have the ability to be an Asian man and challenge Harvard's discrimination because I made that decision?
Senator, I'm not able to answer your question. You're asking me about hypotheticals and
well, I'm asking you how you would assess standing if I came in and said, I have decided I identify as an Asian man.
I would assess standing the way I assess other legal issues, which is to listen to the arguments made by the parties, consider the relevant precedents, and the constitutional principles involved, and make a determination.
Okay, that's you not answering the question again. Because just like you can answer any other question that you feel like answering, you can say, I'm a woman. Senator such and such is a woman, and the person who's most important to me in my life, who's here today, is also a woman. That's my mother. So you can answer that. But then when he says that there are people, and he even included himself in a couple of the, I guess, hypotheticals, you could have then let him know in a matter-of-fact way what you considered to be a woman or not, in my opinion. But again, I don't know who she's protecting.
Okay, let's go back to your favorite topic of this hearing, which is the criminal law cases you had as a district judge, and in particular the cases involving child pornography. Now, your defenders, both on the Democratic side of the dais and also in the press, have suggested that the criticism that has been raised has been somehow cherry-picked, that it's only some specific examples. So I'm going to give you an opportunity to discuss each and every case you've had, because looking at your cases, and I've now examined all of the child porn cases you've had as a federal district judge, there is a very consistent pattern. So let's start, and by the way, I'm excluding the cases. So Senator Durbin and Senator Coons focused on the Nickerson case, the Fife case, the Nguyen case, and the Hilly case, I'm excluding those because those are not child porn cases. Those are actual sexual assault of a child, which is markedly different. And I will concede when you're dealing with sexual assault, you have been willing to impose stricter penalties. So let's focus on actual child pornography cases. And let's go through each of them, because if it's right that we're cherry picking, then you should be able to explain quite powerfully. Now, your justification is that you're following the statute. And as you know, 18 U.S.C. section 3553 lays out the factors.
Just so I'm clear, do we support Ted Cruz? Because again, guys, y'all know this is a journey that I'm new on. When it comes to politics and whatnot, I am just actively starting to pay attention to it. Actively starting to pay attention. Let me know if you support Ted Cruz or not. If you support, what he stands for as a politician, as a man. He says he's from Harvard University, and I believe so is Justice Ketanji Brown Jackson is also from Harvard as well. So, yeah, feel free to let me know whatever y'all want me to know about Ted Cruz so that I can have more understanding. Is this someone I should look into further, just by himself, not even, cross-examining a judge, just by himself?
That as a district judge, you had to consider in sentencing. And let's start with the Hess case, United States versus Hess. Now, in that case, a man sent 6 pictures of a prepubescent girl that he claimed was his daughter to an undercover law enforcement officer. Officers found over 600 images of child pornography, including images of sexual acts being performed on prepubescent children. The defendant pled guilty, and I believe in all of these cases the defendant pled guilty. So there's no question about guilt. They came in and pled guilty in your courtroom. The charge carried a mandatory minimum sentence of 5 years and a mandatory maximum sentence of 20 years. The sentencing guidelines recommended 151 to 188 months sentence. The government, as part of a plea deal, agreed to argue for 60 months, but didn't agree that that would be the sentence, simply that they would advocate it. And you, in turn, sentenced Hess to 60 months. So, under the terms of the statute, why did you choose to sentence Hess to the absolute lowest possible sentence you were allowed to sentence under law?
Thank you, Senator. I have spoken at length throughout this hearing about these cases. I've said what I'm going to say, which is I've taken every case seriously. These are very horrible
I'm asking you specifically about the Hess case.
I've taken every case seriously.
So you're not going to answer that?
These are very horrible crimes, as was that one. And as a mother, having to look at these pictures, having to follow Congress's directive, having to listen to recommendations like the government in that case, which argued for 60 months, I imposed the sentence that I believed was the sentence that was required by law.
So I believe you, and I've read your sentencing hearing in each one of these cases for which we have transcripts, and there are several of which we don't have transcripts.
Is it just me, or could she have answered the question in the amount of time that she took to say that she already answered the questions? I'm just saying, I get it. But when you're at a hearing and she knows as a judge, if someone's sitting in front of you and they are a plaintiff or they are a defendant and they're being cross-examined by attorneys, you're going to tell them to answer the question. You're not going to allow them to say, well, yesterday when I was sitting here and someone asked me a similar question to this, I went into great length discussing the answers that they can go back into yesterday's transcript and receive. So with that said, I'm not going to, I don't get that. You could have answered that question and been on with your day, but unfortunately, it's something about that question. Well, something about the answer to that question that will make you look bad.
So in each of these cases, you read from the same script. So in each of these cases, you say that the distribution of child pornography is an extremely serious federal crime. And you point out that the crime involves people who are taking pictures and videos of real children while the children are being sexually abused. In Hess, you pointed out that he had hundreds of images of children in sexually compromised position. Some of them engaged in sadomasochistic acts. All of this I'm reading from you on the bench. And most importantly, the children in these pictures are not knowing and willing participants in the degrading conduct that was being depicted. They were being forced by someone off screen to commit unspeakable acts of sexual violence for the pleasure of the people filming them and for the gratification of people everywhere. And what concerns me is that many of those people have absolutely no shred of empathy for what that conduct does for the children who were being abused in this way. And you read this script in every one of these cases. So you talk about that these are terrible, terrible crimes. But you also, and in Hess, you said, I have to say that what I found particularly disturbing about your offense was that, quote, you apparently concocted a story about having photographed your own daughter, who you purportedly were willing to take pictures of to trade with other people. I know from your comments and from those who know you that you are unlikely to ever harm a child, which I find remarkable that you've got a child predator in your court who says, I'm unlikely to harm a child. And you say, well, you told me that, so clearly you're unlikely. But you say, but in the context of the crime, you represented that you would. That in and of itself is astonishing. So you talk about it as astonishing. You nonetheless sentenced him to the very lowest possible sentence allowed under law. And what's striking is in these cases, in half of them, in 5, you sentenced the defendant to the absolute lowest sentence under law. Let's look at another case. Let's look at United States.
Yeah, I would like an answer to that right there, because if you have the ability to sentence someone who's that vile, but you choose to sentence them with the lowest, I mean, what's the automatic lowest we can give them? I get that there's an in-between and there's a highest, but we're going to give them the lowest. I want to know why. Why do those people get the lowest sentencing? Like, do you just think that they're not harmful? Do you think that what they're doing is not disgusting? Do you think that what they're doing is not worthy of being punished? I really want to understand that.
Versus Chazen. Now, Chazen is a particularly nasty case. In Chazen, the defendant was accessed a Dropbox that contained 35 videos and 13 partially downloaded files of prepubescent minor females engaging in sexually explicit conduct. At least 3 of the instances of prepubescent female children were engaged in sexual activity with adult men. The images included the sexual abuse of children, including those as young as toddlers. And several of these cases that you had involved the sexual abuse of toddlers, which is truly horrifying.
Hold on. I want to say we have someone in here who is rolling, and they just now started their own channel and everything. The Question Queens, please make sure y'all go and follow them on YouTube. They are absolutely phenomenal, and you will see them in a few of our videos very soon. Trust me on that, all right? We're just trying to get some things together, and you're going to see. They are amazing, for real. Shout out to the Queens.
In this instance, Chazen pleaded guilty. The guidelines recommended a sentence of 78 to 97 months. The prosecution argued that should be what the sentence was, and you sentenced Chazen to just 28 months. Why did you sentence someone who had child pornography of toddlers being sexually abused to 28 months, 64% below what the prosecutors asked for?
She's not going to answer the question. I don't believe she is anyway, but it would be amazing if she does. Senator, I went through this already, or whatever he is.
Thank you, Senator. You've picked out, 7, 8 cases. I've sentenced more than 100 people.
But not to child pornography.
And in every
These are your child
case,
porn cases.
in every case, Senator, I look at the evidence, I look at the recommendations of not just the government, because my duty as a judge is to consider all of the arguments that are made in a case. I look at the evidence. I talk to the defendants about the harms that they have engaged in. Many of these defendants are people who...
Okay, Judge, with respect, you're not answering my question. You're right. You talked to them about the harms. Let me read you again from what you said at the bench. You said in this instance, with Mr. Chazen, you said, among the defendants nationwide who received a below-guideline sentence on the basis of a downward variance as opposed to a departure, the average sentences ranged from 84 to 92 months. So that's what you lay out as the average. Our Democratic colleagues say, well, other federal judges sentence below the guidelines. That is true. A number of federal judges do. Our Democratic colleagues have not pointed to a single federal judge in the country who 100% of the time sentences child porn defendants to markedly below what the prosecution has recommended, unless you have a mandatory minimum and no ability to do so. In this case, you say comparable defendants are sentenced to 84 to 92 months. Sentencing guidelines by statute require you to have similarly situated defendants sentenced to similar sentences, but you don't sentence Chazen to 84 to 92 months. You sentenced him to 28 months. Why?
Senator, I've said what I'm going to say about these cases. No one case.
She is full of sugar, honey, iced tea, man. Bless her for being able to come this far in her career and everything without having to answer any damn questions. She say, look, I'm the judge. I do all the asking of questions. I ask people to answer questions. I don't answer any questions. I ask the questions. And now she cannot even say, well, I know on average we could give them between 60 to 90 months, but it was just something about him, you know, he just looked so warm and cuddly, and I believed him. It was believable. So I don't believe he'll do it again. And he was just a nice guy. He had a family. He sent me something for Christmas. I don't know, whatever the case may be, but I do know that she at least comes off in this conversation to be full of sugar, honey, iced tea. In my opinion, that's just my opinion.
Can stand in for a judge's entire record.
Okay, but I'm discussing every one of your cases. So if you're not going to explain it,
Senator, would you please let her respond?
No, not if she's not going to answer my
Well,
question.
if you're just going to give a speech, then you shouldn't engage in questioning.
You are not taking my time. If you want to filibuster, you're welcome to do so, but do it on your own time.
I would at least give you an opportunity to speak, and you should give her an opportunity to respond.
If she wants to answer the question, I asked her why she
Please allow her to answer the question.
I asked her why she sentenced Chazen to 28 months when comparable defendants, in her
let's
own
hear the
words,
answer.
were sentenced to substantially higher, and she said she's not going to answer. I would welcome your
didn't
answer,
hear that.
please.
Senator, I didn't say I'm not going to answer.
Okay, well,
I
then
said
please
my
tell us,
answer.
in this case, Chazen, why did you sentence him to just 28 months?
Senator, you're looking at the record. I don't have the record here. What I will say is that in every case, I looked at the recommendations of not only the government, but also the probation office, the defendant, the record, the evidence. I took into account the seriousness of the offense. And
By the way, one of the
ruled.
striking things in Chazen, the prosecutor comes in front of you and says, this is the prosecutor's argument at this point, and the prosecutor says, I understand from my experience before Your Honor's objection, policy objections, to the 2G2.2 sentencing guidelines. And he goes on to say, however, in this case in particular, the 4-point specific offense characteristic is justified because it contains sadomasochistic images of infants and toddlers. I'm trying to understand how you see someone that possesses images of infants and toddlers being sexually violated, and you sentence them to 64% below what the prosecutor is asking for. You don't provide a justification other than a generic concern that the guidelines are too high. You don't provide a justification as required by statute. So I'm asking you to take the opportunity to explain to this committee and the American people why in 100% of the cases You have people with vile crimes, and you have language saying they're vile crimes. But then you sentence them to very, very low sentences. And why do you consistently 100% of the time choose to do that?
Senator, no one case can stand in for a judge's entire sentencing record. I've sentenced more than 100 people. You have 8 or 9 cases in that chart.
Okay, Judge, you said that before. These are the 8 or 9 child porn cases. I will say, to correct the record,
I just say to the judge, there's no point in responding. He's going to interrupt you.
Thank you.
Look, I appreciate the chairman trying to filibuster, and if you don't like your witness's answers, you're welcome to provide your own. She is declining to answer the question, and Chairman Durbin, if you want to join her on the bench, you can. But Chairman Durbin,
my job is to make sure.
Chairman Durbin, I'm not interrupting your questioning.
I'm asking you to give her a chance to answer.
But she's consistently said she's not going to answer. I want to clarify for the record, by the way, the case I was discussing was Cooper and not Chazen.
Wow, look like it's getting a little turned up in there. Look like the gentleman like, look, shut up and let her answer a question. He's like, look, she's doing a whole bunch of talking, but she's not answering the question. What do you want from me? Now, if you want to get over here on the daggone stand and let me ask you some questions and you answer them for her so that she not have to answer them, then let's go. You can get on the stand and we can do it that way if you like. Well, I'm simply just letting you know that you're not allowing her to answer the question. You're not allowing her to give a speech that's not going to answer the question. She's wasting our time. She's wasting our time. And I guess this is the way things go. I don't understand all these forums, the way that they do things. But if this is how they do things, look, you're never going to get anything out of it. And honestly, I'm getting nothing out of it. Absolutely nothing out of it, to be honest with you. But y'all feel free to let me know whatever y'all want me to know. The rest of this conversation will be in the link below the video. So feel free to go check this out if you have not already. I'm assuming that most of you who have seen this reaction has also seen the original as well. But if you haven't, the link will be below. And thank you so much for clicking play. I appreciate y'all. Make sure you click the like button, the bell button, and subscribe if you've received any value from this at all. Okay, love y'all. Peace out.